Hello, everyone. My name is Ileana Abouassi. Thank you so much for joining us today. I'm from the American Autism Association. For those of you that don't know, we're a nonprofit organization that provides support to people with autism and their families. We do this in a number of ways through education with workshops like the ones we're doing today. We also have a varied amount of resources on our website, such as guides, grants, information. We also have an autism help hotline that families can contact and find resources in their local area. We support families all over the country and even all over the world in helping them get access to resources and support in their local neighborhoods. Another thing our organization focuses on is therapeutic recreational programs. So we take programs such as ballet, soccer, and basketball, and add an educational component and host them in an inclusive environment. Today, as I said, is a part of our workshop series, our virtual workshop series, in which we started last year to offset the support that we were lacking with the changes that occurred due to the pandemic. We typically hosted about 4 parenting workshops a year. Now, since we're able to do them virtual, we've hosted about 15 in the last year and a half, which is really exciting. Today, we're with the Inclusive Education Project to talk about the nuts and bolts of special education. The school year is around the corner for a lot of us. I think the timing is different depending on where you're at, but today you'll have the opportunity to ask questions and get answers and share stories with each other. So we're really looking forward to today's webinar. Before we begin, I just wanted to go through some housekeeping rules. We will ask that everyone keep themselves on mute throughout the webinar. This webinar is being recorded, so it will just help with sound and people that will view it in the future. So please do keep yourself on mute. We also recommend watching on speaker view to make sure that your format and your settings is the way that it's intended to be seen. And then utilize the chat as much as possible to interact. I know that our speakers today are really keen on having an interactive and engaging webinar. So please put responses to their questions and then ask questions throughout the way that we'll answer. I'll be chiming in throughout to help voice your questions that you're putting in the chat. So don't hesitate to ask anything. If you don't want to put it in the chat for everyone to see, you can just privately message me and I'll ask it on your behalf, and I won't name any names. And then if you do have to pop out for any reason, or maybe if you're watching this a little later time, it is because we're recording this webinar. So once again, thank you all so much for joining us today. I'm going to pass things on to the Inclusive Education Project, who will be doing our presentation today. So Vicky, on to you.
Thank you so much. Let's see if this works with the screen share.
It will work.
We manifested it. Okay. So thank you so much for that lovely introduction. My name is Vicky Brett, and I am here with my business partner. I was going to say partner in crime, but we're attorneys, so we probably shouldn't say stuff like that.
Probably not.
Amanda Salogi. Amanda's actually going to tell you a little bit about our nonprofit.
Yes, so we are the Inclusive Education Project. We started out as special education attorneys representing children and families with regards to their education rights. And we quickly realized that there was more needed to be done in this space, from providing pro bono legal aid to awareness presentations like we're doing today. There's not enough resource. There's a lot of resources out there, but not enough connection to families on what their rights are with regards to their IEP and getting services. There's a lot of misinformation out there, unfortunately, about who qualifies for IEPs and what services. And so, one of the things that we do with Inclusive Education Project is try to spread more awareness and get the conversation started about, how we can be changing the system for the better. We do have a podcast that helps kind of spread that message. We have guests on weekly that are amazing to kind of jumpstart the conversation from different topics, similar to the one we're going to have today. And so that's a little snapshot of who we are.
Yeah, and even though we are attorneys, we are not your attorneys. This presentation is specifically for the purpose of disseminating information. While we are attorneys in California, and there may be some specific California laws that we go over, the Individual Disability and Education Act is a federal law. So the basis of a lot of things is applicable all throughout the United States. So while there may be things, for instance, in California, we have specific timelines for when assessments may need to be done. It might be different in your state. So please kind of follow up and check in on that. So let me just go and make sure that I can. Oh, maybe it's down, not. Oh, I love technology. Okay, here we go. So kind of already gave an overview of special education, but it's free and specifically designed instruction to meet a child's specific needs. So the federal law had created the Individuals with Disability and Education Act. This act was created in fairly recently, if you think about a lot of the laws that we've had. It's been around since the 70s. So special education feels very much like the Wild West. It is individualized, so it is specific to the child. So while there are some kiddos that appear to have similar disabilities, we can't just label them and throw them into a classroom and just be like, okay, our work here is done. Each individual child needs to have an individualized education program that is designed to meet their specific needs. And Andrew F. is a Supreme Court case that came out in 2017 that really broadened that a bit to also include circumstances of the child. So this isn't just specific towards children living with unique needs. This can also include if the child is a child in the foster care system, if the child is homeless, if the child is of Asian American descent. While all those things should have been taken into consideration before, now it is something that needs to be actually spoken to and for at IEP meetings. And let's go down.
So when we look at the purpose of the law that Vicki just mentioned, the IDEA, we're really looking at one big broad concept, which is a FAPE, a free, appropriate public education. So public education, you're in the public education system versus a private school. Public education, pretty easy, free, easy to understand. The word appropriate is where the bulk of our work comes in, the bulk of the work of the IEP teams, the school. What is appropriate? Generally, it needs to be based on the child's individual needs and circumstances. So what is appropriate for one student may not be appropriate for another, even if they have the same label, disability, circumstance, because it's not just about one factor. We have to look at all the factors combined to really determine what is going to be appropriate for that child. And, Andrew F., the case that Vicki mentioned, really goes further to talk about those circumstances and how that a FAPE and that appropriateness must lead to meaningful or contemplate meaningful educational progress. So not just we have this idea that it could be appropriate, it needs to actually lead to appropriate progress, meaningful progress for that child. And progress for one child might be very different than progress from another. So again, going back to that individualization, everything we do, everything we talk about is individual to each child.
So when we're talking about special education, and the idea behind the IDEA was for placement in the least restrictive environment. And by the way, we speak in acronyms all the time. So if we've said an acronym that you're not familiar with, please let us know. The Inclusive Education Project's initials are IEP because a lot of kiddos have individualized education programs, IEPs. So we're so funny with that, right? Anyway, so when we are talking about where we want our kiddos to be taught, it is in the least restrictive environment. So that's the general education setting. And we want our children with unique needs to be educated with children who do not have unique needs. And the research has been there for 30 years that early intervention and peer modeling is everything. So we love it when parents are able to find us when their child is 2.5, 3, because oftentimes what we'll see is the district will take over from regional center and they will offer special education preschool. It's great. We have all these services. It's early intervention. But more often than not, what ends up happening is the child is therefore put on this educational career track of being in a special education class throughout the lifetime of their education with that school district. Does not always happen, and it does sound like a good idea, like, oh yeah, there's going to be more speech and language, and there's going to be this, but we know that children need to be with typical peers so that they learn. So that's something that we always talk to our clients about. And a good question to always ask when you're at one of those early IEP meetings is, how many of the kiddos that attended your preschool program ended up in general education kindergarten? If it's 90% and they have that data and they are willing to share that with you, fantastic. That means that they're actually doing what they're saying they're doing, and a majority of those kiddos will go into the general education setting. If they are fumbling around and like don't know how to answer you or just refuse to answer you, that might give you an inkling as to, we're putting this label on this kid, and this is how we're going to treat this kid. Least restrictive environment also applies to academic and non-academic activities. So the right to be in after school clubs and programs and things like that. It shouldn't be a separate club or program for the child, or assemblies, right? They should go with all their typical peers to those things.
So how do we get there? How do we get to even the point of talking about the IEP, placement in least restrictive environment, FAPE? The first step to getting in the door is through assessments. So assessments are done by the school district and they require a parent's consent. So typically the school district gets a referral for the student, whether it's through, in California, the regional centers or other agencies when they're young. It can be a referral from a parent saying, I'm concerned about my child for X, Y, and Z reason. Referral can come from a teacher, from a soccer coach, from a speech therapist, can come from anybody that's working with the child and has direct knowledge of the child, can say, you know what, there's something here that I feel they might benefit from extra support, or they're struggling in some way or another. And that can be, like we referenced at the beginning, the circumstance that they're living in, that they're in foster care, that they have been homeless for a couple of years, that they have gone from placement to placement, and so from school to school, and are displaced and have missed a lot of school. It could be that they are receiving cancer treatments and they're in the hospital. So their circumstance can cause that referral. The referral should cause the school district to do assessments right away. Certain states have provided additional requirements for a timeline. So for instance, in California, when there's a referral made, an assessment plan has to be provided within 15 days. Other states, it's what's reasonable. But ultimately, the parent is the one that consents to these assessments, and the school district is supposed to assess in all areas of suspected disability. So if the child has, let's say, a speech and language delay, the school district should certainly conduct a speech and language assessment, but they shouldn't stop there. They should dig a little bit deeper to determine what are all the areas that the child might be struggling. It might just not be speech and language. It might be social skills. It might be some factor of academics. It might be vocational. Vocational skills are, the student is a student, right? So their job is regarding their behavior, their fine motor skills. So there's a lot of components that impact every day-to-day life, from their health, that should be assessed in these assessments. And on our slide, we have a list of the majority of that get assessed, but it should be individualized to that student based on their needs.
And just as a quick note, we have 13 eligibility categories in special education. At 13, but we have a catch-all, which is normally other health impairments, and we have them all here, right? So it's one of those things where you'll see intellectual disability, you'll see autism. Autism, like at some point, was within the code section, but you have your range of deaf and hard of hearing, hearing impairment, orthopedic, multiple disabilities. Sometimes we'll see our kiddos that have cerebral palsy and are blind, that may fall under there. Traumatic brain injury, we have a couple clients. Specific learning disabilities is another one that we see. Are dyslexia kiddos fall under. Sometimes our ADHD, ADD kiddos fall under other health impairments. And we've also had clients with very specific genetic deletions that like literally that's the name of their condition, that fall under other health impairments, if there's no intellectual disability present with that. And really those assessments, when we talk about the eligibility categories and being eligible for special education, Amanda likes to say that these are like 13 doors, right? And you just have to walk through one of these, because again, even though we are using the easiness of here's a label, that is just a starting point. Once you get through the IEP door, right, of being eligible for special education under speech and language impairment, if for some reason down the line or through those assessments, your child also needs occupational therapy because they have fine motor skill deficits, then you should get that as a service for your child. Oftentimes, I think maybe about 15 years ago, there was this real big push, at least here in California, of a lot of parents wanting their ADHD type kiddo to be diagnosed with autism, because within one of the biggest districts in the nation, LAUSD, they were providing like a certain set of classes and therapy. So if you wanted speech and language, occupational therapy, specialized academic instruction, like if you had autism, you automatically got it. Now, obviously, since then, that's like not appropriate, and LAUSD got hit on that. But I think that mentality still exists of, oh my goodness, I have to have autism or else they're not going to give me this. No, that's not true. As Amanda said, like we are looking at the specific needs of the child. And if the child requires speech and language services, then that's something that the child would need to get.
So now we get to the big kahuna, the Individualized Education Program, the IEP. There's a lot of components in the law about what an IEP is, what goes in an IEP, how it gets developed. The first stage is having that initial IEP meeting, where the first part should take place reviewing the assessments that were done, going over the strengths and weaknesses of the child, the areas in which are impacted by the circumstances, the disability, the underlying conditions of the child. That initial meeting determines the eligibility that we just talked about, determines what the child's needs are and how we're going to support that child. Once that IEP, the initial IEP is held, you are required to have an annual IEP at least once a year. But this is one thing that a lot of families don't know because the schools don't tell them, is you're not only having one IEP meeting a year. You as a parent have a right to ask for a meeting at any time throughout the school year, not just at the time that the annual is due. At any time where there is a change in circumstances, there's a concern, there's clarifying needing to happen, a change in services, a change in placement, you can request an IEP meeting and the school is required to hold one within 30 days. But that initial IEP is that kind of starting point for those annual. Now, the IEP meetings must be done at a mutually agreeable date and time. The school district is not allowed to just come and say, we're going to have it on this day, be there or be square. They can propose a date, but the parents can then propose alternative dates if that doesn't work, the time doesn't work. We know a lot of parents work or have other kids, so it's not as easy for them to just drop everything to come to a meeting. So it should be a mutually agreeable date and time. The meeting notice, the copy of the IEP, all documents that are provided must be given in the language of the parent. So it must be translated, both the meeting, what happens in the meeting, and the documents itself must be translated in the language of the parent. Who's part of this IEP meeting? Certainly parents are an important member of the IEP team. Then there are certain requirements that the IDEA requires. So it's not just going to be the teacher and maybe the principal, and oftentimes that's who shows up, but it should be at least one general education teacher, regular education teacher, one special education teacher, one district representative that has the power and authority to offer what's in the IEP and has knowledge about the different programs and supports that the district is able to offer. There must be someone who can interpret and explain the assessment. So typically that's going to be the person who conducted the assessment. So they're able to explain. They should be qualified, certified, both to conduct the assessments and to review and make proposals. If it's appropriate, the child can be invited, but doesn't have to be. Typically, when we get to high school age, our higher functioning kiddos, we think it's important to have them in the meeting for part of the time to kind of talk through what their concerns are and talk through what it is that's being proposed. But typically for our younger kiddos and for those who are lower functioning or have social emotional challenges, we find it a little bit more difficult for them to sit through a meeting that is all talking about their challenges. So you as a parent have a right to say, I don't want my child to be there until they reach the age of 18, and then the child can, unless the educational rights have been transferred, the child does have a right to be there. And then the parent can invite, and so can the school, any additional member that is appropriate to speak to the needs of the child. So for the district, that might be a speech and language pathologist, an occupational therapist, anyone else that's working with the child. For a parent, it can be an advocate or attorney. It can be anyone who has knowledge or experience working with the child that can gain a perspective. And it can be a friend of a family member. It can be someone who, if the parent needs support. It is intimidating to walk into a room where we have, 15 people from the district and just the parent. So a parent has a right to invite anyone they believe is appropriate to be part of that meeting.
So what should be in the IEP? Again, each district, each state has a different kind of template for what is part of their IEP, but these are the basics, right? We're going to want to go over the present levels of the child. Where's the child at? What has happened? Have they made progress on their goals? Then we go to the annual goals that they're going to be presenting, right? What are the specific academic, functional, emotional goals that we are going to be focused on for the next year? What is going to be the placement? What are going to be the related services? Are we going to have additional accommodations, modifications? And with special education, the goals drive the placement, and the placement, goals drive the services, and the services drive the placement. So you'll sometimes hear districts say that, and you're just like, what do they mean? Sometimes we'll have a district that provides like 15 goals. And in order to accomplish those goals within the year, the district is providing speech and language and specialized academic instruction in a special day class. And the reasoning is because, well, we have so many goals, the only way we would be able to provide the amount of speech and language that we're offering plus the specialized academic instruction would be in a special day class. So oftentimes you'll hear districts try to kind of justify things like that. But there's so many other things that we can take into consideration, such as accommodations or modifications, and not just in state testing, but within the classroom setting. So modification really changes the way or the information that the child is learning. So if they're in high school and everybody is reading the like traditional Shakespearean Romeo and Juliet, your child may have the plain English Penguins publishers version of Romeo and Juliet. They're still accessing the same curriculum, Romeo and Juliet. It's just the level at which they're accessing it is going to be different than their peers. Whereas when we talk about accommodations, oftentimes it's the way in which the information is being presented to the child. So for instance, if all the third graders are going to be doing 100 multiplication questions for homework, your child, because of their attentional deficits, may only be able to get through half of them. So they're going to be doing all the odd ones. They're still doing the same exact homework that their peers are doing. It's just going to be at a reduced load because of their attentional deficits. We also go over extended school year and transportation. Extended school year really is, I believe it's any days, I think it's an excess of 10 school days. So while most people think summer, some districts may have like a 3-week a winter break. That could be extended school year, that services or some type of specialized academic instruction could be provided. We don't see that very often, but it does exist. And then when we are talking about kiddos that are at least 14 or older, we are looking towards the future, so past high school. So a transitional plan may be included. We always tell clients it's always good to think about transition, vocational early on, and those are the skills that we're working on. But the transition plan, typically during high school, is one in which you'll have it in writing, and there's specific goals and things that need to be addressed to find out, what your child is interested in after high school.
So you've held your IEP meeting, you've discussed all the programs and services, and what are the next steps? So in order for a school district to implement the IEP, all the plans that were put in place, the parent has to first consent. A school district cannot provide any supports or services without that parent consent. However, parent consent does not have to be the full thing, all or nothing. A lot of school districts put a lot of pressure on parents to sign immediately at the meeting and put a lot of pressure to sign the whole thing. But the law does not require that. The law does not require you to sign in that moment. You can take it home, digest it, review it with a friend, a family member, anyone else that wasn't able to attend the meeting. You can take some time. You can ask more questions if they come up. So you can certainly consent at a later time, but just know that services can't begin until you do provide that consent. Some school districts will try to rush you, but of course, it's most important that you understand what services and supports you're consenting to before you consent. The other big part about consent is the consent itself. What are you consenting to? Do you agree with the entire plan? Do you only agree with part of the plan? A very big common situation is with that initial IEP when students sometimes are 3 years old, where a school district proposes some goals and services, speech therapy, let's say, and they all sound good to the parent, but then the proposal is for the placement to be in a special day class, not a general education class. Can a parent say, I agree to these other components, but I don't agree to the placement? Absolutely. You can provide what we call partial consent. It does not have to be all or nothing. And so what we recommend is these IEP documents only have a little line for you to sign consent. So we recommend that you put typically something on that line. You feel free to say, see attached document, write it out, say, these are the things that I agree with. These are the things that I don't agree with. You have every right to do so. And the district has to implement the components that you agree to, and they cannot implement the components that you do not agree to. When you disagree with a support or service, let's say a program has been provided for a while, let's say the child has been in general education for some time, then the IEP team says, we really think that the child needs a little bit more support. They need to be in a special day class. And that's what they're proposing for the next annual IEP. If you as a parent think that the child is doing well in general education, maybe it's not perfect, but that was the point of the IEP, to make changes to the program, and you want to try it out. You have a right to say, okay, well, I don't agree with the change of placement to the special day class. I want to continue to be in the general education class. You have every right to do so. And what happens is that triggers, look at the bottom of this slide, what's called stay put. For that placement, you remain in stay put for the placement And the school district cannot implement a special day class placement without your consent. So you would be in a state put placement.
So then what typically happens and when do people come to us? When there's a problem. So one of the first ways that a school district can try to tackle the situation where they're trying to take away a service, let's say specifically in California, because different states have different ways of implementing, right? The IDEA has like the 4 instances in which they need parental consent to start that initial evaluation, when we're conducting reevaluations, before providing special education services to the child for like the first time, and then if they the district wanted to invite outside agencies for like a child's transition. So for instance, in Arizona, they can do a lot without parental consent, but let's say that it's one of those instances in one of those states like California where they're trying to take away speech and language from 1 hour to 30 minutes a month, just to make it easy. And the parent doesn't agree. The IEP team can reconvene and then they can have an amendment IEP. So if you have a team that's super active, they'll say, okay, well, we're going to take some more data. We're going to really kind of almost build their own case as to why the child no longer needs the special education services of speech and language for an hour. They may be passing all their goals. There may be some other type of data that they have from like assessments. I'm trying to think of how often. Sometimes things get resolved, sometimes they don't. If they don't get resolved, then there's blatant violations. A compliance complaint can be filed by the parent. It would be under, in our state, the California Department of Education. And it's really about non-compliance. So let's say the child had 1 hour of speech and language a month, that speech and language pathologist went on sabbatical and was gone for 6 months, and it took them 6 months to find a replacement, and your child did not get that 1 hour of speech and language that they were entitled to under their IEP. That would be non-compliance. They did not comply with the IEP, so you could file a complaint with the California Department of Education. They would investigate. It's very black and white. And most of the time, it's a very simple remedy. Well, the child missed 6 hours because that was 6 months. So district, you need to provide those 6 hours back to that child. But what happens if the child regressed during that time? Not only did they not get their 6 hours, but now they're even further behind in their speech and language, and if they've been harmed in a different way. That's where mediation or due process requests come in. Mediation only is just that. Here in California, you have the Office of Administrative Hearings that can facilitate a mediation only, and a resolution session can happen, and you can reach an agreement within a settlement agreement. The perks of that is that oftentimes parents are able to resolve things. It's not in the IEP, but it is in an agreement, and districts like that because then that's not public record. It can be confidential. And oftentimes, without even getting the Office of Administration, the OAH involved, districts will have an alternative dispute resolution timeline. So maybe you've tried the IEP amendment and then it gets kicked up to the special education director. You have a sit down and maybe you're able to reach an agreement at that point. Our bread and butter obviously are the due process hearing complaints. This is where we would file a complaint on behalf of your child. Mediation would be agreed to, and then a hearing would be set by the Office of Administrative Hearings if we were not able to resolve at mediation. Due process complaints can vary. Some attorneys here in California can write as little as a few pages, just really detailing out like, here are the issues, here's what we're seeking as a form of remedy. Amanda and I do things a little bit differently. Our due process requests tend to be on the lengthier side, anywhere from 20 to 30 pages, because we really try to paint a whole picture of what has happened to the child, how the child has been affected, and why our remedies that we're pleading are so important. we find that we're able to resolve oftentimes at a resolution session, which occurs within 15 days of the filing of a complaint, or at mediation, rather than having to take it all the way to hearing. Mostly because, we're using the district's own documents against them. There's a lot of evidence there, and the form of mediation is a form of compromise, so that we're able to kind of try to rebuild the relationship between the parent and the district.
So that is IEP at a glance, a gist of the basics of IEPs. And so we'd love to open it up to any questions that anyone might have specific to the topics that we talked about, or anything else IEP related.
Hey guys, that was great. Thank you so much for sharing all that really useful information. We did get a few questions, and not everything is specifically IEP related, but a lot of it is just education related. So I'll ask them, and if you feel comfortable answering them, that would be great. So one of the questions that we got in the chat is just about kind of discovering your child's special talents and using like school resources to assist with that. Do you have any advice on that?
Yeah, so when we look at a child's circumstances, it's not necessarily always going to be challenges that they have. Sometimes we have students that we call twice exceptional, ones that might have challenges in certain areas, but strengths in others that are, very high scores, say in math or in science or in music or something like that. So the school district is required to take into consideration a twice exceptional child, a child that has extreme strength in something. So if the student needs supports for certain areas of academics, or say social skills or speech communication, but has strengths in certain areas of academics, the school must still challenge them. So we do see this a lot with students getting bored in general education classes because the academics is not challenging them. So the IEP team has to take that into consideration, whether it means providing supports, say for our older kiddos in AP and honors classes. They have a right to be in those classes. Even if they still need supports in those classes, they have a right to be challenged. And sometimes that does mean the elective classes as well. So if there are music or dance or athletic programs that they still would need some supports to access, but could excel and be challenged, then the school district has an obligation to ensure that they are able to access those programs.
Okay, great. Thank you so much. We just got another question. What are the expectations for a private school in terms of the IEP?
So private schools typically do not get federal funding, and the reason why public schools are obligated to follow federal law, the IDEA, is because they are getting the federal funding. Private schools get money from the parents, so they are able to, essentially discriminate against children with disabilities. While there are some private schools that do offer special education type programs and services, it's only whatever they feel that they can provide. So there is no obligation for them to follow the eligibility, the assessments, anything that we discussed today.
Great, thank you so much. Another question we got was from someone who said that my district told me that we could not do partial agreements to the IEP, and said that they essentially had to sign everything if they wanted any part of the support that they were offering. Instead of being in a special needs classroom, they wanted their son to be in a general ed class and receive the speech services on the side. That was ultimately their goal, is what they've shared. Now that he's in a special day class, they want to know if they can go back to a general ed class setting without the school's recommendation.
So certainly the thing that you were told that you can't do partial consent, that's not accurate. And unfortunately, the reason why our jobs exist is because school districts do things all the time that they're not supposed to. Sometimes it's out of ignorance, sometimes it's out of trying to save money, whatever the reason may be, there's a lot of misinformation out there. So you certainly can consent. You can always withdraw consent if you consented to something because you were misinformed, you were told one thing and it wasn't necessarily true, if you were misled, you are always able to withdraw consent. Where it becomes challenging is with placement. If you withdraw consent, typically the school isn't going to act immediately. If you were to say withdraw consent to a special day class, oftentimes that does result in some type of alternative dispute resolution or due process needing to happen. A lot of times, we're able to come together with a school district and find a compromise. But that's typically what we see happen. But you certainly have a right to withdraw that consent.
And just to like add, you can always disagree. I think leaving an IEP meeting early and not like staying start to finish is hard to do, especially if you don't disagree, but you want it well documented why you don't agree. Again, like I mentioned, the IDEA is only specific about parental consent being needed in those 4 instances, right? The initial evaluation, reevaluations, before they provide special education related services for the first time. And then if there's a transition IEP meeting, inviting outside agencies. So your state may be different than California. In California, we can certainly agree to one thing and not the other. But in other states that are more aggressive, I would say, they can make those decisions without you. But Amanda brought up a good point of being able to withdraw consent, but you really want to keep your record as clear as possible. So that means not having just verbal conversations, like following up in emails. Email is the quickest way at times, and like a specific email. I know there's a lot of different like Dojo and Learning Genie and all these like online, like you want to be sending an actual email so you can pull it up in the future if you need to use it, because a lot of those like apps, it's hard to like pull and extract like all the conversations that you're having with the teacher or emails that you had sent through there, and plus the district controls it, and I don't know, I don't trust the district. So I would say, you email it from your private email to like the director of special education, if they're involved, to the principal, like always CC 1 or 2 different people on those correspondence so that you can use it in the future if you need to.
Yes, anything in writing is going to be your best bet for everything special education. You're providing the district with notice. If you say something verbally to an IEP team member, a teacher, a principal, let's say when you're on campus, technically they should be memorializing that conversation in writing, especially if it's a request or concern, but that rarely happens. And, teachers get distracted. There's other parents, other kids. So the best way, if you do have a conversation, send an email afterwards or send a letter, send something that says, hey, like we just talked about this, just wanted to confirm, and follow up.
Fantastic. Thank you guys. Great advice. Document everything, parents, caregivers, everyone. Another question that we received, which I know that a lot of parents have asked this to our organization over the course of the last year and a half. And although some schools are returning back to in-person, I think there's a fear of going back to a hybrid model or even fully back at home. And during this time, a lot of families struggled to get support for their students during the pandemic when everyone was at home. So do you have any recommendations that with all that's going on, how can they get some support in home for their children?
Yeah, it's a mess. This school year, I think, is more of a mess than it was last year, especially here in California. I think in a lot of states, there is this push to return to in-person fully. There was no contingency plan for a variant or for some of these kiddos that are medically fragile and may need to stay home. So we're left in this weird kind of like rocky boat like that we're trying to navigate in terms of independent study. So independent study was offered to those kiddos that did not wish to return in person, and that was applicable whether you had an IEP or not. And obviously the issues that we're seeing is that our special ed kiddos cannot do things independently. So the independent study model is completely inappropriate. Some of the ways that we're combating that are if the child does need temporary home placement services. There's something called home hospital where a doctor would need to provide a note. It would be temporary in nature, but they would need to provide a note indicating why the student would not be able to return to school. And here in California, home hospital is 1 hour a day, 5 days a week of a teacher actually coming into the home. It gets a bit more complicated when the child has an IEP, and this is post-COVID times. Pre-COVID times, we were able to get more than an hour. We were able to get services and things in the home. But nothing has changed in terms of what is obligated under the IDEA, under the federal law, what needs to be provided to a child with special needs. So last year, when kids were at home, and the districts are saying, well, we're not sending district people into the homes. Okay, you can send non-public agencies into the homes if those non-public agencies are operating in person. So we saw a lot of that. This school year, it really just depends on the local laws that have been passed in your state and also within your district. Because here in California, the independent study model, if a school district didn't even have one before and it was going to cause a financial burden for them, then they were not obligated to provide it. So districts are having to scramble as to how to, and districts, not even just states, it's like the individual districts are scrambling as to how to respond. So, the only kind of, without knowing any more information, document everything. You ask for whatever, however, whenever, and you force them to say no, and you force them to say why. I think that is just the state of affairs that we're in, because although it is individualized and we are having, like, for instance, Amanda and I are going to a slew of IEP meetings where, within the first 30 days of the new school year to see how we are going to be placing our kiddos that cannot return and what supports and services we can provide, obviously giving the district a minute to respond to us, and also to see how they're even going to address regression, which nobody's thinking about because everybody's freaking out about how to provide services currently.
Yeah, and remember, the federal law has not changed. So that obligation that we talked about at the beginning, a FAPE, appropriate public education, it still exists. There was a lot of talk at the beginning of the pandemic about our former Secretary of Education trying to get waivers for states, waivers of these IDEA obligations. That did not happen. Congress did not pass any kind of waiver situation. So we are still dealing with the federal law. Even if state laws have come and said, okay, you can do this or you can do that, that is going above and beyond. The federal law still exists. Now, unfortunately, as with a lot of things with special education, enforcement of this requires a parent to file for due process. There was some guidance that came out last summer by the Federal Department of Education that essentially said that in these kind of weird times, in order to determine if regression has occurred and if compensatory education, additional services are obligated by the school district, when the students resume in-person instruction, the school district should be holding IEP meetings to determine where the students are, any regression that occurred. So when Vicky's talking about these 30-day IEPs, these IEPs that are happening right now, that's essentially what we're talking about. Now, the school district should be doing that on their own. They should be doing it for every kid. But just like we've said before, it doesn't always happen. So we do recommend that you have an IEP, check in with the team, see where the students are at. But ultimately, at the end of the day, the easiest and best way of enforcement is a parent taking action and either filing a state complaint with your State Department of Education or filing for due process. Which technically under the law, parents can file for due process on their own, but because school districts are represented by attorneys, it often becomes very challenging for parents. So, seeking the assistance of an attorney is often recommended for these processes to get, whether it's you've paid for services over the course of COVID to supplement what the school is not providing, or you're still needing services that the student might be entitled to.
Fantastic. Thank you both so much. So the last question is about working with high schools or students at the high school level and incorporating building vocational skills into their education somehow. There's some parents that understand that, maybe college isn't for their student. So building vocational skills will help them and eventually building a career while not going to college and looking at those alternatives. Do you have any recommendations on how to get schools and to incorporate that into their education? Because it's so far off now when we think about high school students, it's so heavily emphasized to go to college, right? Like I feel like that's something we hear so much, but there are people that don't do that, and there's plenty of careers outside of that realm. And so how can parents work with schools to incorporate building vocational skills earlier on rather than doing a transition to adulthood program after, and try and do that during the high school years? Do you have any advice on that or experiences with that?
Plan is supposed to occur at 14, right? So any interest surveys and just, really having to start that conversation. Like I had said, you can start that conversation as early as possible. If you know your child is not going to be receiving an actual diploma or maybe a certificate like here in California, then we'll kind of focus in on like the functional math, functional English language arts. You don't want to do it too early. You don't want to do it in third grade. We want to try to give the child a minute to acclimate, or they might have delayed processes, but by junior high you have kind of a picture of what it is that you want, and that's why we wait until about 14, and obviously freshman in high school to start with that transition plan. And that really can be anything. They're going to have their generic, like fill out this, or like maybe we'll work on a resume or something like that. But you can go above and beyond that. Also inviting other agencies. So here in California, the Department of Rehabilitation can be at the IEP meetings, as well as the regional center. And I know regional centers are really unique to California, but they often take over after a district has provided the 4 additional years after high school of a vocational program. And you don't have to limit yourself. There are independent agencies and independent nonprofits that do vocational work. So give them a call. Hey, what are you guys looking for when you are working with a child? Are you looking for a specific level of comprehension? Are you looking for the language, like strength in language? So then that way you can really focus in on the goals during high school, so that, if you just need functional math to get to this type of job, then like, let's have functional math, right? And then let's really focus in on the speech and language skills of the child, because there's going to be certain things, right? We want them to be familiar with a resume. We want them to have the social emotional skills to be able to go in and ask for a resume at a grocery store, right? So those are the types of skills and things that just off the top of your head that you can really focus in on during those IEPs, just vocationally speaking, with not even in a transition plan, but just within the IEP. An IEP is not just academics, it's social emotional, and it is vocational. So that should always be weaved within. And if they don't have a vocational goal, say, how are we going to address their vocation and get them to start doing the work that they actually need to do, so that they can better inform you as to what services they can offer to your child.
Okay, fantastic. Thank you both so much for all of the wonderful information today. For those of you that are watching live, or for those of you that might join us later to view this webinar, their information is on the screen. Please do visit their website and check out their podcast, because it is fantastic and very informative. Again, thank you everyone for joining us today. Thank you both so much for this incredibly useful presentation. And I hope everyone has a lovely rest of your day.